Good morning, students. Settle down, please. Today, we are going to look into a highly critical topic for your upcoming university examinations. The question is, discuss the principles of natural justice in domestic inquiry and its importance in disciplinary action. Let me be very clear right from the beginning. This is a standard, recurring, 16-mark long answer question. You simply cannot afford to be casual with your preparation here. The evaluator expects a highly structured, precise answer script. So let's break down exactly how you're going to write this.
Our synopsis for today's session is exactly as follows. 1. Introduction and meaning. 2. Core principles. 3. Application in inquiry. 4. Importance in disciplinary action. 5. Landmark case laws. And 6. Consequences and conclusion. You must write this exact synopsis block on the very first page of your answer script. Heading number 1. 1. Introduction and meaning. Take down these notes precisely as I dictate them. 1. Introduction. A domestic inquiry is an internal investigation conducted by an employer against an employee for alleged misconduct. Such inquiries must conform to the principles of natural justice to ensure fairness and legality under labor laws like the Industrial Relations Code 2020. Now listen carefully, students. The explicit mention of the Industrial Relations Code 2020 is strictly mandatory here. It's an absolute must. The evaluator is actively looking for updated contemporary statutory references. If you only give a general definition and fail to mention the 2020 code, you will not secure full marks for the introduction, period. Moving on to the next part. 2. Meaning of natural justice. Natural justice means fairness in action and adherence to basic procedural standards. It aims to prevent arbitrary decisions, bias, and misuse of authority. When you present this on your answer script, you must list these 3 preventative aims: arbitrary decisions, bias, and misuse of authority as distinct separate bullet points. I do not want to see a messy, continuous paragraph. Clear vertical bullet points make the evaluator's job easy, and let me tell you, that translates directly to better marks for you. Heading number 2. 2. Core principles of natural justice. This section is the absolute heart of your 16-mark essay. I strongly advise you to underline this main heading twice with a ruler on your paper. Now the first principle, read it carefully. Nemo Judex in Causa Sua, which is the rule against bias. No person should act as judge in their own cause. Inquiry officer must be impartial and unbiased. Make sure this Latin maxim is written without any spelling errors. Practical impartiality is strictly required by the courts, and therefore by your evaluator. If the inquiry officer has even a remote personal stake in the disciplinary matter or is a witness to the alleged misconduct, the entire proceeding completely collapses. The officer must be a neutral umpire. Write this next principle down exactly. Audi Alteram Partem, the right to fair hearing. Employee must be given proper notice of charges, opportunity to present defense, right to cross-examine witnesses. Let me elaborate on this, students. The right to cross-examine the management's witnesses is the absolute bedrock of natural justice. It cannot be skipped, and you certainly cannot merely summarize it in your essay. If the charged employee isn't allowed to question the witnesses deposing against them, well, the hearing is just a sham. You must explicitly emphasize this triad on your paper: proper notice, presenting defense, and cross-examination. Note these final 2 core principles. 3. Reasoned decision, also known as a speaking order. Decision must be supported by reasons and evidence. 4. Evidence-based findings. Decision must rely on relevant evidence, not suspicion. Let me provide a deep academic clarification here, because this is where many students lose marks. There is a vast, unbridgeable gap between suspicion and hard evidence. An employer might deeply suspect an employee of theft, but a domestic inquiry cannot punish based on mere conjecture. The inquiry officer's report must be a speaking order, meaning it absolutely must articulate the logical link between the evidence presented and the final guilty verdict. I am warning you, do not mix up mere suspicion with actual evidence in your answers. Heading 3. 3. Application in domestic inquiry. This section right here demonstrates the procedural mechanism of the law. You need to show the evaluator that you understand how theory actually translates into corporate practice. Consequently, this must be presented sequentially. Note the chronology. 1. Charge sheet with clear charges. 2. Opportunity of hearing. 3. Impartial inquiry officer. 4. Recording of evidence. And 5. Reasoned findings. You must reproduce these 5 steps verbatim. Framing these strictly chronologically on the exam shows a practical understanding of how a domestic inquiry functions in real life. Think about it. You obviously cannot record evidence before issuing a charge sheet, right? Logic and sequence are paramount in procedural law. Next heading, 4. Importance in disciplinary action. In the examination hall, you must smoothly transition to this second half of the prompt. The question asked for principles and their importance. Do not write 10 pages on principles and only 1 paragraph on importance. You have to balance your answer script. Let us dictate the points. 1. Ensures fairness and justice, as it protects employee rights. 2. Validity of proceedings, because noncompliance makes the enquiry invalid. 3. Prevents arbitrary punishment, which limits misuse. 4. Judicial approval, since courts uphold only valid enquiries. I expect you to be by-hearting these specific subheadings. By writing these exact phrases, you guarantee the evaluator knows you fully understand the severe legal consequences of bypassing natural justice.
Section 5. Landmark case laws.
Students, put your pens down for a moment and give me your complete attention. Anybody can write general theory, but case laws are the absolute only way to elevate an average answer script to a top-tier grade. If you do not cite relevant jurisprudence, you aren't writing a law paper, you're writing a secondary school essay. Consider this citation carefully. Workmen of Firestone Tire and Rubber Co. versus Management established that proper domestic inquiry is essential for valid disciplinary action. Let's break this down. The brief facts here involve the management outright dismissing workmen without holding a proper, legally sound domestic inquiry, arguing that they had an inherent right to discipline. Well, the Supreme Court's ratio de decidendi was crystal clear. Before an employer can impose a severe penalty like dismissal, holding a proper domestic inquiry respecting natural justice is a mandatory prerequisite. The absolute relevance of this case is that it stripped employers of arbitrary firing powers under the Industrial Disputes Act. Here is an exam tip. Write Workmen of Firestone Tire and Rubber Co. versus Management in a separate boxed format. It forces the evaluator's eye to see it and award marks immediately.
The second case, State of Uttar Pradesh v. Shatrughan Lal, held that violation of natural justice vitiates disciplinary proceedings. Pay very close attention to the vocabulary here, vitiates. In formal Indian legal vocabulary, to vitiate means to destroy the legal validity of a proceeding entirely. It renders it defective and void. The background facts of this ruling involved a government employee facing disciplinary action who was denied copies of the witness statements recorded against him. The court ruled that failing to supply the relied-upon documents is a direct, undeniable violation of Audi Alteram Partem. Therefore, the entire proceeding was vitiated. Remind yourselves to heavily underline this citation on your answer script. It captures the evaluator's attention and proves your firm grasp of procedural technicalities.
Final section. 6. Consequences and conclusion.
Never, ever abruptly stop writing your answer after the case laws. Every 10-mark or 16-mark essay must end with a formally structured conclusion to score full marks. It demonstrates true academic discipline. Write down the consequences verbatim. 7. Consequences of violation. Inquiry becomes void. Punishment may be set aside, possible reinstatement, or fresh inquiry. Let me elaborate severely on the practical impact here. If an employer's inquiry is set aside by the labor court due to a procedural lapse, the court may order reinstatement with full back wages. Just imagine an employee sitting at home for 5 years during litigation, and the company is suddenly ordered to pay 5 years of salary for zero work, simply because the inquiry officer failed to give a proper notice. The financial and operational impact on the employer is absolutely devastating.
We conclude the essay with this paragraph. Conclusion. Principles of natural justice are the backbone of a fair domestic inquiry. Their observance ensures transparency, fairness, and legality, making disciplinary actions just and sustainable. Read it word for word. Memorize it. This standardizes your legal closure and neatly ties up the 16-mark requirement. And please, ensure your handwriting remains legible right up to this final full stop.
Before we dismiss the class for the day, I want you to consider this final question. As future legal practitioners, how will you ensure an employer's domestic inquiry does not become an empty ritual masking a predetermined termination? Do not just be by-hearting the provisions for the sake of the exam. When you eventually step into the actual courtrooms or sit as legal advisors for multinational corporations, it will be your ethical and professional duty to ensure that the rule of law is actually practiced. It shouldn't just be performed as a theatrical drama to fire an unwanted employee. Reflect on this deeply. Class dismissed. Prepare well for your examinations.